Welcome, everyone. Thank you for joining us today. I am Christina Ewig. I'm the Faculty Director of the Center on Women, Gender, and Public Policy here at the Humphrey School of Public Affairs at the University of Minnesota. This is the second year in a row in which a group of centers and programs across the university have come together under the umbrella of what we call WHEEL, the Women's Health, Equity, Empowerment, and Leadership Group. We came together last year to also host a webinar series for International Women's Day. And this is our first event in our series for this year's International Women's Day. We chose as a group the theme of the social and political factors that impact women's health. So mark your calendars and register if you have not already for the next two events in the series. The first will be March 3rd at noon, a panel discussion called From Global Health to Safety, Why We Need the Every Woman Treaty, which is co-hosted by Global Rights for Women along with the Human Rights Program. This has a focus on how the international legal system can be a positive force for women's health and safety. And then on March 10th at 8 a.m., we have a panel discussion called The Power of Personal Stories and Communities to Reduce Disparities in Global Maternal Health, hosted by the Center for Global Health and Social Responsibility. And there we'll move to the community level and focus on local community action and women's health. Today, I am thrilled to introduce Professor Fiona de Londras as our keynote speaker to kick off this events series. Here at the Center on Women, Gender, and Public Policy, we deliberated on what we could do for this year's International Women's Day under this general umbrella of the social and political factors that impact women's health. And from our vantage point in the United States, it was hard to ignore the ways in which national and state level policies are having an enormous impact, especially on reproductive health, and in particular, access to abortion. In the fall of 2021, when we were thinking about what to do for International Women's Day, we were in the throes of the US Supreme Court decision then, and more recently again in January of 2022, to not intervene in the challenge to Texas's recent law, which bans abortions after 6 weeks. And it's designed to evade judicial review by allowing private citizens to bring lawsuits against anyone who, quote, aids and abets a prohibited abortion. So this bounty hunter scheme in Texas has devastated access to abortion in that state. And at the same time, we know that on the court's docket, they've recently heard arguments on the Dobbs versus Jackson Women's Health Organization case in Mississippi. That's based upon a Mississippi law that would ban abortions after 15 weeks. We're waiting now for the court decision on that case. And while we wait, a number of US states have also passed laws similar to Mississippi's laws that will go into place should the court decide that that law can move forward. So in other words, the context and outlook for women's reproductive rights here in the United States is not particularly good, especially when it comes to abortion access. For those of us that may not understand the gravity of abortion restrictions for women's health, education on these risks is critical. And for those of us that are eager to protect women's health in this country, we're in need of a bit of inspiration. So we are therefore very pleased to host Professor Fiona de Londras to learn about the Irish experience in liberalizing Ireland's abortion law and the lessons it might offer to a US audience at this juncture. Ireland's more recent history of lack of access to abortion can be informative of the dangers that lie ahead for US women. And while I know the Irish story is not one of complete success, we also hope to learn from Professor de Londras about the political strategy behind abortion liberalization in Ireland and what lessons it might offer to those that want to protect reproductive rights in the United States. Fiona de Londres is a professor of global legal studies at Birmingham Law School at the University of Birmingham and honorary professor at the Australian National University College of Law. She is the author, with Mayright Enright, of Repealing the Eighth, Reforming Irish Abortion Law, published by Policy Press in 2018. Professor de Londres was herself heavily involved in the campaign to repeal the constitutional ban on abortion in Ireland. She also helped to draft revised legislation and appeared in a number of key public debates on that issue. We are looking very much forward to Professor Delondres' talk, which is titled Repeal, Reform, and the Continuing Politics of Abortion Law in Ireland. Before I hand the floor over to Professor Delondres, let me make a note to our audience members. The chat is disabled, but the Q&A is fully functional, and we hope that you will use the Q&A function to ask your questions. Professor Delondres will take questions after her presentation, and I will be monitoring the Q&A and present your questions to her after her talk. And so now, over to you, Professor Delondres, and thank you.
Thank you so much, everybody, for coming. And I want to particularly start by thanking Christina and her colleagues at Repeal for inviting me to speak in this important series of webinars marking International Women's Day this year. I'm only sorry that I can't be there in person with you all. I want to mention that as I join you today, academics in the UK are engaged in a protracted and escalating industrial dispute with university employers around pension devaluation, precarity, casualization, and gender and race pay gaps. And so I join you today in my personal capacity, which I hope you'll understand. I also want to express my sincere solidarity with all of those, including in particular women and girls who are living in situations of aggression, armed conflict, and state violence in Ukraine, Yemen, Afghanistan, Syria, Palestine, and more places around the world at this time when those aggressions feel particularly close to me sitting here in Birmingham in the UK, and to pay tribute to the people who are working in those conflict zones as well as in border areas to ensure that pregnant people who are displaced and who seek abortion care are able to receive it in extremely challenging circumstances. So in this next week or two, as our employers and governments and other public bodies spend their conventional annual week of celebrating women, I hope that we can all join together to seek to ensure that their platitudes are translated into meaningful action, both in conflict zones and elsewhere. So I think meaningful action is a good jumping off point for what I want to speak to you about today, which, as Christina has said, is abortion law reform in Ireland. Over the last few years, Ireland, which is my home country, has become lauded as an exemplar of progressive abortion law reform. And in some ways, that moniker or celebration is deserved. In 2018, we went from having one of the world's most restrictive abortion laws to a state-funded, free to all abortion care on request in early pregnancy system. Thousands of people who previously undertook international abortion travel, self-managed and safe but unlawful abortion, or simply non-consensual continuation of pregnancy can now receive care in Ireland. And that is something to celebrate and to be proud of. However, as in most other countries, Ireland's new abortion law is a system of regulation and provision that is imperfect, sometimes cruel, and remains wedded to problematic paradigms in which abortion is seen as exceptional, is highly proceduralized, is often denied, and is overly medicalized. This afternoon, then, I want to outline in brief how this law reform came about, surface a few of the flaws in the new law, and then reflect in ways that hopefully will resonate with some of you in your ongoing struggles for reproductive agency in the United States on the persistent political reluctance to normalize abortion and integrate it as part of sexual and reproductive healthcare, and indeed as part of our sexual, intimate, and reproductive lives. Every abortion law has its own story and emerges from its own particular context. Ireland is no different. In 1983, we took what was then seen as a pioneering step in anti-abortion lawmaking by inserting an express pro-life provision into the Irish Constitution. This was done by referendum, which is the only way that a formal change to the Irish Constitution can be made. And the provision, the Eighth Amendment to the Constitution, received overwhelming support in what was then an extremely conservative, highly religious society, in which institutions, and in particular the institutional Catholic Church, enjoyed significant social, political, economic, and cultural dominance. There is neither the need nor the time here to go into the background of the Eighth Amendment or the ways in which its wording and proposal were influenced by a fascinating transnational coalition of anti-abortion activists driven significantly by US-based interests in anti-abortion constitutional innovation and experimentation. It's sufficient to say that the constitutional text that was inserted imposed a near total ban on abortion and secured that ban through what I'll call a triple lock. So the first part of this triple lock was the Constitution and the electorate. If the text of the Constitution inserted in 1983 were ever to be changed, this could only happen if a majority of the electorate voted for it, because referendum is the only mode. The second part of the triple lock was politics and the Irish Parliament, known as the Oireachtas. Before the people would ever have a chance to vote on a referendum to change the Constitution, the Oireachtas would have to agree to propose it through a piece of ordinary legislation on which we can reasonably assume politicians would be given a free vote. And the third part of the triple lock was the courts. If the text inserted through the Eighth Amendment were to be stretched to allow abortion in some circumstances or narrowed to make it as restrictive in its effects as possible, that would primarily be achieved through litigation. Now, in the 1980s, anti-abortion activists in Ireland had a great political advantage: conservatism. All three institutions that made up this triple lock, the people, the parliamentarians, and the judiciary, were highly conservative. Recall that birth control was not legalized in Ireland until 1978, and even then only for married couples and for bona fide family planning purposes. Divorce was illegal. Consensual sex between men was illegal. Illegitimacy was a powerful legal institution and concept. Marital rape was not a crime. Institutions in which unmarried women who became pregnant were effectively incarcerated and in many cases had their babies removed from them through coercive and non-consensual informal adoption, continued to operate with implicit state support. The Ireland that I grew up in was not a liberal place. And through a campaign of concerted and highly intelligent litigation, anti-abortion activists capitalized on the institutional and social conservatism that had allowed the Eighth Amendment to be inserted in the first place, to ensure that the Eighth Amendment would operate as what Emer O'Toole has called a noose around the Republic's womb. So through these court cases, they ensured that information about abortion could not be provided, that medics could not refer people for abortion care in another country, no matter how complex their health situation was, that young women were frequently, in fact, routinely stopped in airports and ports if it looked like they might be going to try to have an abortion. Foreign magazines had advertisements cut out of them before they were sold in shops so that nobody could get information through them about where abortion could be secured internationally. So this triple lock was secured by a huge level of institutional conservatism, societal shaming, particularly around sexuality, and widespread misogyny. However, society changed. But even as society changed, the triple lock continued to secure the constitutional status quo that banned abortion. Whatever concessions to progress they were very slight. In 1992, the Supreme Court confirmed that under the 8th Amendment, abortion was legal in Ireland if there was a real and substantial risk to the life rather than the health of the pregnant person, and that risk could only be averted by termination of the pregnancy. Much to the chagrin of anti-abortion activists, the Supreme Court confirmed that that risk could include a risk of suicide. The political reaction to this case, which emanated from a 14-year-old girl who was a victim of sexual violence seeking to travel to the UK to terminate her pregnancy, was not to see the problems in the constitutional law and seek to change them, but rather to seek to reverse the modest progress that the Supreme Court case represented. So the Oireachtas twice proposed referendums to the people that would reverse the provision or the understanding that suicide was a risk to life that would qualify one for legal abortion in Ireland. On both occasions, the people voted against that proposition, but it was still not until 2003, 20 years after the 8th Amendment, and more than 10 years after this case, that any legislation was passed to put in place a system to actually determine whether someone was lawfully entitled to access abortion under the 8th Amendment. Even then, that new law, which was called the Protection of Life During Pregnancy Act, imposed a process so burdensome, so convoluted, and so demeaning that only people who could not travel or self-manage their abortion ever subjected themselves to it. In 1992, 2 referendums were held to clarify that a pregnant person was entitled to travel to access lawful abortion care in another country. But all this meant in practice was that the state would not stop you from traveling. It certainly didn't mean that the state would help anyone or fund their healthcare, as we do in other areas where resources are not available in Ireland and people travel internationally for medical care. Women therefore begged, borrowed, and stole to travel for abortion, were exposed to exploitation and violence from people who understood their vulnerability, and often ended up having children simply because they could not afford to have an abortion. Another referendum in 1992 resulted in an express constitutional provision that abortion information could be provided as long as it was provided in accordance with the law. That new law was not passed until 1995, and it was again extremely restrictive. It did not regulate abortion misinformation. It enabled the funding of abortion information provision or pregnancy information provision by groups that were in effect anti-abortion and would not provide any information about abortion services. And it made it a criminal offence for a medical practitioner to facilitate abortion care in another jurisdiction. Again, no matter how complex the person's health situation was. An indication of how restrictive this legal regime that persisted until 2018 is that in the case of Amanda Mellett against Ireland, the UN Human Rights Commission found that the Irish law imposed pain and suffering of such gravity on women who received diagnoses of fetal impairment as to constitute a violation of the right to be free from torture, cruel, inhuman, and degrading treatment. The Irish government's response was to pay Amanda Mellett an ex gratia compensation payment. The triple lock thus remained firm, in spite of all of this. The courts were not in a position to row back from their highly restrictive interpretation of the Constitution, which had become highly entrenched, not least because pregnant women, quite understandably, were not willing to subject themselves to months of expensive and exposing judicial deliberation to seek to establish whether they were allowed to access an abortion. Abortion is time-sensitive healthcare. In Ireland, just as in the United States, women find ways to access it rather than seeking to test and stretch restrictive legal systems through court cases. So the jurisprudential picture was unlikely to change. It was pretty clear from around the early 2010s onwards that the electorate was in favour of substantial liberalisation, but they could not express that in a meaningful way unless there was a referendum, and the political establishment was not willing to give people a referendum. Abortion was, and in many ways remains, a topic on which Irish politics wants as little to do as possible. The political institutions are conservative, and often the loudest voices interacting with them are those who hold a minority anti-abortion position, who are very well resourced and who have very prominent platforms in politics and media institutions in Ireland, even though they don't represent in any way a majority or even a very largely held view. So politicians would need a nudge, and a hard one, before they would risk a referendum, as they would have thought of it. As is often the case, that nudge came from a woman dying. This woman was Savita Halappanavar, who was denied miscarriage management care that was considered by the hospital in question to constitute abortion and thus to be prohibited. She died from sepsis. The second thing that provided the nudge was a simple accident of political arithmetic. After a general election, no party could form a government alone, and a new government depended on a feminist independent politician, Catherine Zappone, to be formed, and she made her support conditional on a political process leading to a referendum being put in place. Together with huge activist pressure, the mainstreaming of pro-repeal positions in social, cultural, and advocacy interactions, and the increasing clarity that repeal represented a moderate or middle Ireland position and not some kind of extreme position within the electorate, all led to this referendum on the 25th of May, 2018, in which 2/3 of a huge turnout of the electorate supported the removal of the Eighth Amendment from the Irish Constitution. So the Eighth Amendment was gone, the triple lock was broken, and now the Oireachtas, the Parliament, had to take on this task of legislating for abortion. During the referendum campaign, the Department of Health had published a draft outline of the legislation that it would propose if the Eighth Amendment were repealed. This isn't unusual in a referendum in Ireland, to give an indication of what you will do. The idea of doing this in the repeal referendum was for at least 3 reasons. First of all, it would give the electorate a sense of what they could expect if the constitution was changed, and that is perfectly normal within referenda. Secondly, it would give politicians a sense of what they would be expected to vote for in the aftermath of a successful referendum, and give the government a really strong argument to convince reluctant parliamentarians to vote for it on the basis that the people had implicitly endorsed the approach by voting for repeal when they knew what the draft law would look like. Thirdly, and importantly, I think, from a tactical perspective, the draft law attempted to predict and respond to anti-abortion arguments that would be made during the referendum by making it clear that what the government would do would be to propose and implement a very limited regime of legal abortion. Now, all of these 3 dynamics are in many ways tactically and strategically necessary, but they also have within them traps, and they operate as traps. They also allowed the Eighth Amendment to operate as a shadow over the referendum and the post-referendum lawmaking. In order to reassure what the political establishment assumed were reluctant, concerned, or conservative voters in what they predicted would be a very tight referendum, the proposed law was really limited. And there were repeated assurances that there would never be so-called late-term abortion, or that a mandatory waiting period would be required in order to support women in making decisions about accessing abortion. And critically, that abortion would never be legalized on the grounds of fetal disability. In other words, a combination of institutional conservatism, political nervousness, and the potency of anti-abortion talking points meant that what was proposed as a new law on abortion provision would in reality be extremely limited, and that there would be no political incentive and perhaps might even be political costs to deviating from the conservatism of that proposed law in the post-repeal legislative phase. And that is precisely what happened. Although the proposed law did go through the usual parliamentary processes and hundreds of amendments were proposed by both anti-abortion and pro-choice politicians, the Minister for Health steadfastly refused to accept any substantive amendments to the bill. What was contained in the outline bill debated during the referendum is what was contained in the final law. Both the Minister and the government as a whole treated that outline as a kind of covenant between the Parliament and the people, even though the outcome of the referendum and the exit polling showed that actually they had miscalculated the mood of the Irish people, which was far more progressive than they had anticipated. Nestled into that dynamic of simply delivering what they said they would deliver was the inherent institutional conservatism of the political system. There was little desire to go further, largely because this system and the institutions that built on it continued to cling to pre-repeal paradigms of abortion as tragic, difficult, traumatic, and exceptional, rather than the reality for most people of abortion as healthcare that enables them to proceed with their chosen life courses, including parenting and other caring endeavors. This is also reflected in patterns of over-medicalization and imposing regulations that operate as barriers in practice to accessing abortion without any evidence base to support them. Another important dimension in the referendum campaign that shed its shadow on the lawmaking that followed repeal was the discussion of self-managed abortion. In Ireland, as in many other countries and many parts of the United States, medication abortion and its easy availability shifted fundamentally the legal discussion about the regulation of abortion. As Sally Sheldon has put it elsewhere, the state cannot control swallowing. MIFE and MISO are safe and easily accessible, and they are also capable of safe self-administration. And so women in Ireland bought them. They bought them from safe, reliable online providers like Women on Web. They were given them through feminist networks of care, with other feminist activists acting as abortion doulas for one another and empowering people to take control of their reproductive lives with the assistance of these transformative medications. However, within the referendum campaign, self-managed abortion was presented as a failure of the state for good, argumentative, tactical reasons. It was presented as the abandonment of women and girls to their own care, as exposing them to faulty or mislabeled drugs and those who might sell them, of exposing people to dangers if they did not seek post-abortion care following complications. Of course, as I said, there was a logic to the rhetoric of presenting self-managed abortion in this way, which was to try to generate a sense that it was not good enough for us to leave women and girls to have to self-manage their own abortion. But as a result, there was very little space for the emancipatory and transformative potential of self-managed abortion and for the way in which it challenges the notion of early abortion as a serious or complex medical procedure. This is also reflected in how the new law works. So how does it work? For everyone who's pregnant in Ireland, there is now the ability to access a state-funded information helpline and website called myoptions.ie. This provides clear, accessible, and non-directive information in a range of language and formats. It, on the helpline, has trained nurses who can answer people's questions and reassure people And it also provides people with information of doctors who are nearby who provide abortion care. So it helps people to avoid refusals based on conscience. Up to 12 weeks LMP, which in reality is about 10 weeks of pregnancy, abortion is available on request, without any charge, and without restriction as to reason. There are no special rules for minors. Instead, the usual rules of capacity and consent apply. One can access abortion from any community doctor. You do not have to go to the doctor you're registered with. So it's one of the only kinds of healthcare in which that is the case. However, there is a mandated 3-day waiting period from the time a person seeks abortion care to the day on which it is provided. These waiting periods have absolutely no clinical function, and they operate as a substantial barrier to care, especially for people in remote areas. Public transport is very bad in rural Ireland. So like, how do you get to a doctor? Or people without independent means of transportation. And of course, for adolescents and for people who live in coercive or violent environments where it's very difficult to get one opportunity to go to the doctor, not to mention two. Furthermore, the clinical guidance, which is the way in which the law is given effect in practice, requires that medication abortion can be provided by general practitioners, so just in your neighborhood surgery, up to 9 weeks LMP, and people can take the second dose at home, but in hospital settings thereafter. So that is in reality from 7 weeks pregnancy to get medication abortion in a hospital. This is the case even though hospital and tertiary care in Ireland is grossly under-resourced, and there is almost no evidence that tertiary care facilities are helpful or required for medication abortion between 9 and 12 weeks of LMP. This artificial cutoff puts extreme pressure on resources, including ultrasound facilities, causing delays in what is already a super short window for accessing abortion care. So while it is true that medication abortion is widely available and thousands of women have been able to access abortion in this way over the last few years, it is nevertheless burdensome for the abortion seeker and the health system. It is stigmatized and it is unduly and unnecessarily medicalized. After 12 weeks, abortion is extremely limited indeed. Where there's a risk to the life of the pregnant person or a risk of serious harm to her health, it is legally available in hospital settings up to fetal viability. Lots of challenges with this. The legal ground is pretty widely worded. So it is that there is a risk of serious harm to health, not that there is a serious risk. So any level of risk is sufficient to meet the legal requirement. And that was a really important change that we managed to secure. However, the clinical guidance is extremely burdensome. So in the hospital setting, a multidisciplinary team is assembled to assess whether or not there is a risk of sufficient gravity to the health of the pregnant person. And that clinical assessment is taken to be the same as a legal assessment, even though it's actually a higher level of risk than what the law necessarily requires. There are very few resources available for these multidisciplinary teams, including ultrasound and other resources. And so there's quite a lot of delay. Because we don't have specialized physical space for provision, women who are seeking abortion in these situations find themselves in the same spaces as pregnant women, including laboring women and women with newborn children. And of course, the assessment of whether or not the fetus has reached viability, after which live birth is the mandated route, is extremely complex and causes delays. Overshadowing all of this is the continued and serious criminalization of providing abortion outside of the provisions of the Act, so that medics are extremely reluctant to make what they would see as a mistake, either as to the risk to the pregnant person or as to viability. Nowhere, either in the law or the guidance, are the wishes, agency, or self-assessment of the pregnant woman centered. Once you reach 12 weeks LMP, abortion becomes the domain of the medical profession. Once again, quite against the grain of the overwhelming body of evidence around what is effective, acceptable, and appropriate for quality abortion care from 12 to 23 weeks LMP. After viability, so-called, the only situation in which abortion is permitted is either in an emergency or where there is a severe fetal anomaly, which is defined in the law as a diagnosis for the fetus that it has a condition which means it is likely to die before or within 28 days of birth. Once again, the reality of this provision in the law is that very few people who need abortion actually meet it under this ground. This idea of 28 days is extremely problematic. The clinical guidelines once again impose a far more burdensome process than the law strictly requires. There is very little resource to support this. In particular, we have almost no antenatal or prenatal genetic counselors available in Ireland. So labs usually have to be sent abroad, which means a very long time passes before somebody gets an actual definitive diagnosis, if they get it at all. This, of course, causes severe delays and extreme distress for people in these situations. And the definition of the qualifying condition is very strictly applied, but different hospitals define it in different ways. So we know that some conditions are considered sufficient to meet the legal requirement in one hospital, but not in another. And so women find themselves shifted around from hospital setting to setting, with the process starting all over again when they arrive in a new setting. Frustratingly enough, this means, as you can imagine, that abortion travel continues for this group of people who were in fact the center point of much of the campaign for repeal. So known as termination for medical reasons, in Ireland, these families really were the central argument that people connected with in the time of the referendum. And so in spite of all the amazing progress that we have made, the truth is that after 12 weeks LMP in Ireland, it's almost impossible to access abortion unless you are dying or, in a perverse way, lucky. The combination of political conservatism, continued criminalization, restrictive legal legislation, insufficient resourcing, and over-medicalization means that for many people, they face the same choices they faced before repeal: travel or stay pregnant. It's really difficult to express the depth to which people who find themselves unable to access abortion under this law experience it as a betrayal following repeal. Over the last 12 months, I've worked with a sample of about 30 families who received diagnoses of severe fetal anomaly during their pregnancies under this new law, most of whom were not able to access abortion care in Ireland. And I just want to share 3 things that they were generous enough to say to me about their experiences, with their consent, of course. The first is from a woman who's talking about having gone to a session of people who had had the same experience of her and listening to other people. She says, "I heard a bereaved mother saying she could accept that her baby would not live, even though she was heartbroken. What she could not accept was the way her country had treated her. And this really resonated with me. I've been pregnant 5 times, 3 miscarriages and 1 termination for medical reasons, and I have 1 son. I can accept this. I can accept that life does not work out and unfortunate things happen. But what I cannot accept is that the most vulnerable, devastated, and stressed time in my life, I was forced to leave my own country and navigate the English health system." A second woman said, "It's not possible to explain the extent of the heartache when you attend for a specialist prenatal appointment, pregnant with a much wanted baby, hoping they might have a clear, fatal diagnosis that is compatible with Irish legislation. Knowing that the options for termination were so limited meant we were almost wishing the worst for our little girl, when all we wanted was for her to be okay." And the third extract is, "We didn't get to bring our baby home with us. And this will mean we never grieve for our loss properly. It haunts me daily and will do until the day I die. I was asked by the nurse in the clinic what I wanted to do with the remains, and I was in no fit state to decide what I wanted. I was told that if I took them, the remains would have to go and check in luggage. I didn't know what you do with the remains when you come home. Do you call a funeral director? Can you have them cremated? Nobody ever talked to us about this in Ireland before we went to the UK. And so I panicked. And now my baby rests in Liverpool without me. I wish I had them here with me. I wish I had the compassion and support of our health service at this harrowing time. This wasn't even something I had to worry about. Now, anyone familiar with the referendum will hear in those words precisely what you heard from these families under the 8th Amendment. This is the exact same scenario. Repeal was supposed to change it, so why didn't it? Well, to close, I want to suggest 2 reasons, even though there are many. The first is that the 8th Amendment itself continues to have a persistent effect, even though it has been removed from the text of the Constitution. It remains in the shape and the structure and the discourses that underpin the current law. The existence of the 8th Amendment meant that reform had to take on the shape of a referendum, and all the fears and the caution and the pressure of the sense that this was the only chance we would ever have to get rid of this amendment meant that those concerns were mapped onto the campaign. Our imperative was to win, and we'd worry about what happened next later, because unless we won, nothing would happen. So both government and advocates made the arguments that we thought we needed to make to secure that win. Those arguments then shaped what came next. We promised that the law would be restrictive, and it is. We presented abortion as something that required formal medical support, supervision, and oversight, and now it does. All these techniques are visible on the face and in the life of the new legislation. We always knew that there was a chance that they would be, but we felt there wasn't another choice because we had to secure the referendum. And so the cost that this imposes is imposed by and a legacy of the decision in 1983 to constitutionalize the ban on abortion in the first place. And I think there are resonances with experiences in the United States where you see how the very limited jurisprudential reasoning in Roe against Wade and Planned Parenthood and Casey plays out in the kinds of techniques of seeking to undermine them that are visible in new state level legislation and the kinds of arguments that are made before the Supreme Court. And so we know in the world of reproductive rights that our wins have longer term costs, and that reproductive justice is a constant process of revisiting and seeking to mitigate those costs. A second reason why I think the current law repeats some patterns of what came before it is that in making that law, the formal institutions of the state failed to recognize pregnant people as experts in abortion care, design, and delivery. While some people who sought, accessed, and were denied abortion under the 8th Amendment were centered in the referendum campaign at great cost to themselves and their privacy, they were then marginalized in the formal lawmaking process, where to some extent lawyers, but primarily medics, were recognized as the definitive experts in abortion care regulation and delivery, even though, because of the constitutional status quo, most people who worked as medics in Ireland had almost no experience of providing abortion care, apart from when they may have done it during their overseas training and earlier fellowships in obs and gynae, particularly in Canada, but not exclusively. So logics of expertise and certification and procedure were reinscribed on this new abortion legislation, disempowering women and decentering their lived expertise, because these things are central to the sociology of these professions, as are presentations of clinical judgment as objective and legal borderlines of time and place as discernible in a simple and straightforward way. As I speak, there is a process of reviewing the operation of the Act. It's underway. The terms of reference are super restrictive, and we're not really sure how it will work. But we do know that there is overwhelming evidence, empirical evidence, that the mandatory waiting period, continued criminalization, the limited definitions after 12 weeks, and the prevalence of conscientious refusal are operating as barriers to abortion care provision in Ireland. What we don't know is whether there is any political appetite or medical institutional humility, which is what we will need to change that law to ensure that abortion is not only lawful, but meaningfully available to all those who need it in Ireland. Thank you.